Tonight, a Commitment 2018 WISN 12 News election special. A debate with the candidates for Wisconsin Supreme Court.
I've been a judge for almost 10 years.
Milwaukee County Circuit Court Judge Rebecca Dallett, a judge since 2008 and a former prosecutor.
My fidelity is to the law and to the law alone.
Sauk County Circuit Court Judge Michael Skrenok, a Governor Walker appointee in 2015. Tonight, the candidates on their views of the law, the role of the Supreme Court, and the differences between them. And now, live from the Marquette University Law School, here is tonight's moderator, WISN 12 News political analyst and upfront host, Mike Boucher.
And good evening, everyone, and welcome. We are coming to you live tonight from the Lubar Center at Eckstein Hall, Marquette University Law School, where I work as a fellow in law and public policy. Tonight, the first televised debate between the two finalists for Wisconsin Supreme Court, Sauk County Circuit Court Judge Michael Skrenok and Milwaukee County Circuit Court Judge Rebecca Dallett. The two candidates advanced in the February primary, Skrenok getting 46% of the vote, Dallett getting 36%. Madison attorney Tim Burns finished third with 18% of the vote. Our rules for tonight are pretty simple. This is a conversation. We will be talking to the candidates about their qualifications, how they view the job of Supreme Court Justice, and about some of the key issues that have emerged in this campaign. I'll be asking the candidates to answer questions directly and concisely. The candidates may speak to each other, but I'll be managing the time on any given topic, and I'll move the conversation along if necessary. Each candidate will make a closing statement of about a minute or so. And so let's get underway, and Judge Dallett gets the first question. It's actually the same question for both of you, because I think maybe at the beginning of this, and thanks for being here, at the beginning of this we should acknowledge that only 12% of registered voters turned out for the February primary. So a lot of people are still forming their opinions about you. They don't know a lot about you. So I want to ask you at the very beginning here to tell us why you believe you are the most qualified person for this position on the Supreme Court. I don't need you to contrast your skills and qualifications with your opponent. We'll have plenty of time for that. But let's hear about your qualifications right now. And Judge Dallett, we'll let you get underway.
Thank you, Mike. Thanks for having me. We're at a moment in time right now where our rights are under attack every day. Things like clean air and water, equal protection under the law. Women are under attack. And we've got a Supreme Court that's broken. We've had special interest money pouring into these races, buying justice. What we need is someone with experience and values to stand up and repair that court. I've been working in our courts here in Wisconsin for the people of our state for more than 20 years, fighting for our rights. I've been a prosecutor for more than 11 years and a judge for almost a decade. I've heard almost 12,000 cases, and we need someone with that kind of experience, the day-to-day experience with the people of our state and the issues they are facing, to stand up and repair the court.
Judge Skrenok, I'll let you have a few words about your qualifications for this job.
Thank you, and I appreciate you being here and moderating this conversation for us tonight. Thank the Marquette Law School for sharing their facility with us here tonight. When I look at this race and consider my qualifications for the Supreme Court, I really have an experience that our court has never seen before. I have both public sector and private sector experience. I worked in local government for nearly 12 years. I then worked in private practice as an attorney for 8 years. And when I did that, I did a lot of appellate work. I did a lot of work on complex cases that reached our Court of Appeals and our state Supreme Court. And the work that I did on those cases actually mirrors the work that a Supreme Court justice does in terms of the research that's done and the legal analysis that's required to analyze those really complex cases and understand what does the law say about them. And I say that because it's really critically important that the voters across the state understand that when I worked on those cases and I did the research to try to understand what does the law say about these complex questions, there was actually an answer. And when you got done with the research, you didn't get to the end of the road and say, well, it's unclear. I guess the justices can just decide whatever they want. The law provides an answer. And that's really important because I believe it's critically important that the next justice of our Supreme Court actually does just follow the law, interprets and applies the law as they find it, and not as they wish it to be.
So you've talked a lot about the rule of law. So in the rule of law, is there a gray area? So you talked about that you eventually come to a decision and that the law speaks clearly on that. Does it always speak clearly?
It's a very insightful question because it gets right to the heart of what a candidate or a justice on our Supreme Court believes about our Constitution. And I believe that our Constitution must be interpreted as it was originally intended when it was either adopted or amended. And the reason I believe that so strongly is because to do anything else with our Constitution actually has the effect of the Supreme Court amending the Constitution on the fly on a case-by-case basis. And so if you believe that the Constitution must be interpreted as it was originally intended, and you believe that statutes are to be amended based on the words that the legislature used and not the justice's suspicion about what maybe the legislature meant to do but didn't actually do with the words, then yes, the law provides an answer. If, on the other hand, you believe that the Constitution's boundaries are kind of like silly putty and they can move and shift based on the interest of the individual justices, and if you believe that you can find ambiguity in any statute, then as Justice Scalia once said, the world's your oyster. And as a justice on our Supreme Court, you can do whatever you want with the law. And that's why it's so dangerous to have a justice who's not committed to adhering to the rule of law.
Are you suggesting that Judge Dallert is not committed to adhering to the rule of law?
I believe that Judge Dallert is not committed. I know she's said that she said, I follow the rule of law, but she has also said something that, quite frankly, no judge that honestly believes in the rule of law as I've articulated would ever say. She urged voters to vote for her on February 8th on WPR's Central Time program by saying that she would advocate for the policies that need to be changed in order to protect the political issues that she refers to as values that she cares deeply about.
Judge Dallert, I'll give you a chance to respond to that.
Thank you. I appreciate that. And I know that my opponent has mischaracterized many things I've said, and I guess that's the way politics goes. I'm the only candidate that knows what it's like to follow the rule of law every day for almost a decade. I didn't just start my job as a judge. I've been a judge for a long time. I know what it's like to sit on cases, to hear from the parties, to follow the law that I may not have written. And I know how to do that, and I do it well. And that's why I've earned the support of so many around our state, including over 200 judges, attorneys from all different areas, and everyday voters. The problem with what my opponent is talking about is, for him, the rule of law just means following the rules when they fit with his political views of the world. He has shown in his past that he doesn't follow the rule of law. He has advocated on behalf of gerrymandering, rigging our maps in our state, which has been found to be unconstitutional. And he has stood in front of women's ability to access their lawful rights, and he has been arrested twice for doing that. So I think that I am the only one that really knows what rule of law means.
I'll give you a chance. We've got an hour, so there'll be a lot of opportunities to respond to some of what's been said tonight. But I do want to ask you about a comment you made, Judge Dallert, at a forum. You criticized Judge Scrennock, and I'm quoting now, this is the specific quote, for all this rhetoric about the rule of law garbage. The rule of law garbage. That raised some people's eyebrows. What did you mean by that?
Well, what I meant by that is not that the rule of law is garbage. I follow the rule of law. But the way that my opponent has interpreted it is really just to fit his own ends. That's been a problem with our court for about a decade now, where the court is doing the bidding of special interests, doing the bidding of political allies, and reaching end results without following the law. The term rule of law has been used as some kind of catchphrase to appeal to some people in our state, and my opponent has used it over and over and over again. It is a tired catchphrase that has little meaning when what you really mean is you're trying to reach the end result that the people who paid for you to be on the Supreme Court or as a judge want you to follow. That's not the rule of law.
Judge Scrennock.
Thank you. It is something that I say over and over and over again because I believe in it so strongly. And Judge Dallert points to things in my past. And what she doesn't understand, apparently, is that everything changed. Everything changed when I became a judge. Now, again, my opponent has talked about her interest in advocating for policies that need to be changed to achieve her political objectives. I have stated, as she said, over and over and over again that I am committed to the rule of law. Now, it is true that when I was in college nearly 30 years ago, on 2 occasions I did engage in peaceful protests at an abortion clinic. And it is true that as an attorney in private practice, I advocated vigorously for the interests of our clients, and I did everything in my power to assist our clients in achieving their objectives. That's what a lawyer does. But everything changed when I raised my right hand, and I swore an oath to uphold the Constitution of the United States of America and the Constitution of the state of Wisconsin, and I put on that black robe. And as a judge, I am no longer an advocate for any party that comes in front of me. I am no longer an advocate for any issue that's involved in a case that comes in front of me. And as a judge, my fidelity is to the law and to the law alone. And that's the way it must be. That's the way it is in Sauk County right now. And you'll notice she hasn't referred to any case that I have actually worked on in the nearly 3 years I've been on the bench. She goes to things in my past. That's the way it is right now in Sauk County. And I promise the voters that's the way it will be if I'm privileged to serve on the Wisconsin Supreme Court.
Can I respond?
Yes.
I'll point out some things he's done during the campaign, like vowed to uphold the platform of the NRA and take support from a group that he promised to abide by their platform, that is a group that stands for the proposition that all birth control is illegal. And these are things during the campaign. Also has been someone who has taken almost $1 million of special interest money on behalf of the chamber and on behalf of the Republican Party. These are recent things that point to the kind of statements that my opponent is making to this day.
My opponent knows that's not true. The Associated Press did a story on this. My opponent and One Wisconsin Now was asserting that we were refusing to release the information we provided to the NRA. Nobody had actually asked us for it. The day that the Associated Press asked us for that writing, I was in court on the bench in a court trial. I got off the bench at lunch, checked my phone. There were requests from our campaign team. During the lunch hour, we concluded, yeah, we'll go ahead and release everything that we provided to the NRA, which was one single email. It's available, it's been distributed publicly, and it is abundantly clear that I made one promise to the NRA that I have made to every voter across the state, and that is that I'm committed to upholding the rule of law, respecting the Constitution, respecting the separation of powers, and setting aside my personal beliefs. The reason the NRA supports me is because that's all they want. They want justices on our Supreme Court who will simply follow the rule of law and interpret the Constitution as it was originally intended, and that's the only promise I made.
I was going to get to this later, but let me follow up on this, Judge Crennock. The National Rifle Association endorsement, the NRA said they're proud to endorse you. Are you proud to accept their endorsement?
This has become an issue because of what's happened in Florida. And I want to begin by saying that my heart goes out to the victims and their families in Florida, and quite frankly to all victims of senseless gun violence. As a parent of 3 children myself, I really can't begin to imagine what those families are going through. But it's important that we're clear about this issue as it relates and pertains to this campaign. I am running for the judiciary, and it is not the court's role to write new laws or to rewrite existing laws. That is the role of the legislative branch, and I'm confident that they will continue to consider this issue.
Did you feel that you, as the NRA said in an email to Wisconsin voters, they said that you had vowed to protect firearms freedom? Do you feel you vowed to protect firearm freedom?
The entire world can see what I vowed, and it's what I described before. My entire email has been published, if not in newspapers.
And you said there are no promises in that email.
There are the same promises I've made to voters all across the state since mid-June last year, and that is that it is not the role of the court. First of all, it's not the role of judges or justices to insert their personal or political beliefs into decision-making, and I will follow the law. That's my promise. It's my promise to you. It's my promise to Judge Dallett. It's my promise to everyone in this room here today.
I want to go back to this issue of values, because you have said you've talked about values. You said you haven't talked about specific issues or positions on issues, but you've talked about public education, you've talked about clean water, you mentioned some of them in your opening remarks tonight. Are you dancing right up to the line or are you perhaps foreshadowing how you might rule on cases because of things you've said during the course of this campaign?
Voters have a right to know the values that candidates hold. And I think PolitiFact actually did a very good job of looking at the statements that Judge Crennock said that I made that were somehow taking positions on issues. And they made it clear, as I've known throughout the campaign, that I don't take positions on issues, that I've stated values because people have a right to know what those are, and to know that they're voting for someone who has Wisconsin values. I received that same letter from the NRA. It asked me to take a position. It asked for what was called a position letter. And in response to whatever Judge Skrenak told them, whether it was the email or other conversations that they had.
Did you read his
I read
email?
the email, but I don't know what else was said. I know that they sent out to their voters in a piece, not just an email, but a published piece, that he has vowed to uphold their firearms freedoms, to back the agenda of the NRA. That is not something I've been willing to do throughout this campaign. I have not had endorsements because people have asked me to take positions on issues, and I refuse to do that. Wisconsin voters should expect from their justices and judges that we are not going to take positions on issues that are going to come in front of the court potentially.
I'll give you a chance to respond to that.
Yeah, the answer to your question is yes. She is not only dancing along the line, she's crossed the line. Here are Wisconsin's values: honesty, integrity, hard work, follow the golden rule. Those are values. What she is calling values is a liberal activist agenda. She's talked about workers' rights. She's talked about her intention to advocate for the policies that need to be changed in order to protect these values, workers' rights. And lo and behold, she's gotten the endorsement of a number of unions. That's no surprise. She talks about special interests. Clearly, getting the endorsement of a union after you've said that you will advocate for the policies that need to be changed in order to advance workers' rights does go too far, because our recusal rule requires judges and justices to recuse themselves if, either as a judge or as a candidate for judicial office, they've made statements that commit or appear to commit the candidate to a position on issues that will come before the court. So we're talking about workers' rights, women's rights, which is a lot of things are encompassed in it, including abortion rights, clean air and clean water. I mean, just think about for a moment a family farmer or a mom and pop dry cleaner who's undergoing enforcement action through the DNR, and their case gets up to the Supreme Court, and Judge Dallett is sitting on the court, and she is promised during this campaign to advocate for the policies that need to be changed in order to protect clean air and clean water. How on earth would that family farmer or a dry cleaner believe that they're going to get a fair shake and get an impartial decision from my opponent?
Judge Dallett.
Let's talk about this recusal rule, Mike, because this recusal rule that we have right now that my opponent thinks is this great rule, it was promulgated by the very group that has paid for our Supreme Court, that has spent millions of dollars buying justices, that has already spent almost $500,000 on my opponent's campaign, and I'm sure there'll be much more coming, millions, so that he can get up there and rule on issues that involve their constituents, which is a lot of issues. This is the state chamber. This is a big bulk of what the Supreme Court rules on are issues involving business. And what they will expect in exchange for the money that they have spent on my opponent is what they have gotten from the people that they've spent it on up until now, which is that those individuals will do their bidding, that they will sit on cases where millions of dollars have been spent on them and say, I don't have to recuse myself. That's what the rule says.
So you support a change in the current recusal rules for the court. It would essentially, the change you support would say that not federal, but judges and Wisconsin Supreme Court justices would have to recuse themselves from cases involving some of their top donors. That's essentially what we're talking about.
We're talking about millions of dollars that have been spent on these races and no rule that sets an amount by which the public can know that it's fair. The public needs to have confidence that the justices are going to rule on the cases not in their own interest or in the interest of the parties in front of them. We don't have a rule. I absolutely advocate for having a real rule, one where there is a set amount where the public can understand that we have a fair court. We talk about Wisconsin values. Yes, integrity, fairness, confidence in our courts. These are the things missing right now from our Supreme Court.
I want to have you address the recusal issue. You have said in interviews that I've done with you that you think the $10,000 limit for Supreme Court justices is arbitrary. You have First Amendment concerns. But would you concede that to some voters out there, there is an appearance of conflict when a candidate gets hundreds of thousands of dollars in contributions and then has to rule on a case where the people who gave that candidate the money are involved.
Well, here's what I'll say. First of all, we have a rule, and it's important that the voters understand that. My opponent told a crowd last summer that we don't have a rule. In fact, she said it's not. What she said was it's not just a bad rule, it's no rule at all, which is even worse. And we have a rule. And actually, our rule was defended by then Chief Justice Shirley Abrahamson when she ran for election in 2009. And that rule that she was defending was not written by WMC or any other lobbying group that I'm aware of. And what the rule requires is that every judge and every justice in every case considers whether there is any reason why they cannot remain impartial. And if they determine that they cannot remain impartial in the case, they must get off. That's what our rule requires. And I am very concerned about setting an arbitrary dollar limit. And here's the reason why. We have an elected judiciary. And it's important that our citizens are able to fully engage in the campaign process, and they should not have their participation in the campaign stifled by an arbitrary rule. And I want to give you an example.
Briefly, please.
And my opponent talks a lot about special interest money, and she claims to strongly oppose so-called dark money groups engaging in this campaign. Yet she's remained silent on pledged support from Eric Holder and Barack Obama's National Democratic Redistricting Committee, which, by the way, interestingly enough, has right in its name an issue that's likely to come before the court in the next 10 years. And I ask this, now that Eric Holder's group has filed a lawsuit against the governor, should their group feel compelled to completely stay out of this campaign out of concerns that whichever one of us wins this race will be required to step aside if that case then reaches the Supreme Court? I don't believe so. I think that's bad for democracy. And I welcome every citizen and group that wishes to participate in this campaign to be engaged fully. I'll
give you a chance to respond, and then I have two follow-ups and one for each of you, so please.
I respond by, first of all, my opponent needs to go back and look at who wrote the rule, and it was the WMC. And that is the group that has basically effectuated a rule that has resulted in Justice Gableman sitting on the John Doe case when $2.25 million was spent on his race, staying on the case despite a request to recuse himself, and then ruling to shut down an important investigation. Looks like it was on behalf of the bidding of political allies. That's the first thing. The second thing I will say is, to this point, I have gone across the state. I have garnered support from citizens throughout our state. And yes, they absolutely have a right to participate. They have. I've gotten support from thousands, volunteers, almost 3,000 individual contributors. That is participating in the process, and I'm going to continue to do that. My opponent, on the other hand, has waited till the last minute, when there wasn't money to run the kind of ads that he wound up running, to let the influx of special interest money to the tune of almost $1 million come in and blast the airwaves. And that's the democracy he's talking about?
Judge Scrennock, there's a lot here, and we'll try and delve into more detail on all this. But I do want to go back to the case that Judge Dallett cited. This is the 2015 case. The state Supreme Court decides to shut down the John Doe investigation, which was looking into whether or not there was illegal campaign coordination between Governor Walker's campaign and special interest groups, conservative groups. They shut it down. They said they didn't find any campaign finance law violation. Her question, though, is, why should Justice Gableman or Justice Prosser be sitting on that case, hearing that case, when they benefited from advertising by these special interest groups? Do you think they should have been on that case?
Well, I'll tell you what, Judge Dallett talks about the thousands of contributors that she has across the state. Some of the contributors she has are attorneys.
We're going to get to that. So if you could just, we'll get to it. Just if you could address this question, and we'll get to that.
Well, the issue, our recusal, first of all, and I want to be clear, because I did not misspeak, but I was misunderstood. When I said that WMC hadn't written the rule, I was talking about the rule that was in place when Chief Justice Abrahamson defended it. And there was a change then sometime after 2010 that added some provisions that say essentially that contributions and support alone, standing alone, would not be the reason for recusal. But what that change did not take away, and it certainly did not take away for me, is the judge's overall obligation to determine whether there is any reason why a justice cannot be impartial. Now, it also falls to the individual justices to determine, even if they believe that they can remain impartial, whether there would be too much of an appearance of impropriety. And that is committed to the individual justice. That's the way it's always been.
So you're okay if Justice Gableman decides, you're okay with the fact that he decided to hear that case?
Here's what our system requires. And our system is founded on this. And if we can't trust in this, then our entire judiciary falls apart. Our system requires justices with the integrity and the moral character to determine whether they can be impartial or not. And if they cannot, they must step aside. That is required. And so if the justice makes that determination, the question of whether there is an appearance of impartiality or an appearance of partiality gets us to where we are today in terms of whether or not, in the context of another campaign, or if that justice was then seeking re-election, the voters could decide, hey, you got that one wrong. But if the justice can remain impartial, the voters want and need a full bench to decide every case. We don't want 3 or 4 justices deciding a case over a hyper-technical recusal rule.
Judge Dowlett, I want to get to this point that I think Judge Screnach was about to address. And you have talked in this campaign a lot about the fact that you'll recuse yourself from cases that you believe could appear to people to have a potential sense of conflict. The Wisconsin State Journal ran a story in the last 24 hours. It was by Molly Beck, their reporter there. She says, and I'm quoting now, Milwaukee County Judge Rebecca Dowlett has presided over at least one case involving attorneys from her husband's law firm, despite a self-imposed rule not to do so that she has touted during her campaign for Supreme Court. Goes on later to say that Republicans say Dowlett's violation of her own rule, the recusal rule that you've said that you believe strongly in, and the fact that she has presided over 102 cases involving 39 attorneys who have contributed a combined $21,100 to her Supreme Court campaign are evidence of hypocrisy. Given the fact that you've campaigned on this theme of recusal, getting rid of the appearance of conflict, how do you explain that?
Well, the first thing I would say is that I have gone above and beyond what is required. And my self-imposed rule is for the very purpose of making sure that there is understanding and confidence in our courts, which is exactly what I'm running on. If you read the story, the one case that I remained on was one where my husband's firm didn't even make an appearance. It was a foreclosure case, and they didn't show up, and I thought they were off the case at that point. So I understand journalists, and I understand.
What about the donations from attorneys?
I'm happy to talk about that, too.
Yes,
it's very clear in our rules, very clear, that we are absolutely allowed to get contributions from individuals, even if they're attorneys currently on a case in front of us. It's spelled out in the rule. The reason for that is because people are participating in the process. We're talking about a couple $100 here and there.
$2,500
What we need to be talking about are millions of dollars that are coming in, and that's what we need to talk about here. When we're talking about the recusal rule, first of all, we're talking about parties to a case, parties in the case. I ruled the other day on one of those attorneys that gave me a contribution, shutting down his entire case, and it got dismissed. We're talking about the party, the person that's going to benefit from the case, being involved in the case, and we're talking about entities that can give millions of dollars, millions, that are going to give my opponent millions. And those parties are going to be sitting in front of him on cases in that, if he were to be elected, in those races, after they've spent that money to get someone where they are, in order to further their interest in those cases and to make sure that he does their bidding. When we talk about fairness, how does anyone in our state think that's fair? I'll tell you, they don't. People in our state get this. They get it. There is no fairness. There's no sense of confidence. There is a sense that our Supreme Court is bought and paid for by these special interests.
Judge Screnach?
Here's the issue. The voters on April 3rd need to decide between the two of us. Justice Gableman is not on the ballot. I strongly believe that my opponent wishes he were, but he's not. He's chosen to step down at the end of his term. And what the voters are looking for, first of all, I think judicial philosophy is the most important thing, but the voters need to determine which one of us they can trust, which one of us has the integrity, the moral character to do the things that we trust the justices on our highest court to do. And my opponent has made the recusal rule a hallmark of her campaign. She has said over and over and over again that it looks like someone can buy justice or a justice. And in the midst of this campaign, when that's the hallmark of her, that's the calling card of her campaign, she's collecting endorsements from attorneys. She's collecting contributions from attorneys who are actively appearing in cases in front of her. I have attorneys in front of me all the time. I have talked to one attorney about this campaign, and it's our district attorney, and it was about 3 or 4 weeks ago, and the conversation started like this, because I was going to ask him to reach out to other district attorneys, and I said, you know, I haven't asked you for your endorsement yet. And before I was done with my pause, he said, I know, I've been waiting, and you've got it. I have not talked with any other attorneys that appear before me, even about this campaign. Why? Because that's not about the Supreme Court. That's about the Circuit Court in Sauk County right now. And I have parties in front of me. I had parties in front of me today. And they need to know that there's nothing that is persuading me one way or the other about their case. And that's the calling card of her campaign. And in the midst of it, she's collecting contributions from attorneys and then ruling on cases right then and there.
Judge Dallek.
I suppose when you can rely on millions of dollars coming to you from special interest groups, you don't have to go campaign around the state. I mean, our election process, part of what makes it great is, first of all, it's nonpartisan, which I think has been also an issue with my opponent in his positions that he's taken in that regard. But it also is about the people electing their Supreme Court justice. I have done what I would expect and what everyone would expect any Supreme Court justice candidate to do. I have traveled around the state. I have been doing this since June. I have met hundreds of people, thousands of people, and gotten thousands of people to support in every way that they can and participate in every way that they can. My opponent sat and basically depended on millions of dollars coming to him so that he could then make sure that he did what the millions of dollars want him to do. That is not what we have here in our state. We have an election that is based on people, and people get to participate.
I want to pursue this.
I want to address that, though, because she knows it's not true. I've not been sitting in Baraboo since June waiting for something to happen. Between January 1st and the week before the primary, I put over 11,000 miles on my own car driving around the state. And I've been doing this since June, and I've been all over the state. And I've met hundreds and thousands of people, and I've talked to them about this campaign, and I've talked to them about her intention of legislating from the bench and being a liberal activist judge. And that message is resonating, because that's the most important thing that people care about our Supreme Court is, are you going to have a justice that follows the law? Are you going to have a justice that advocates for the policies that need to be changed in order to achieve their political objectives? That's what the voters care about, and I've been all over the state talking about that. And this notion that somehow I've just been sitting in my house in Reedsburg is absurd.
Well, there wasn't enough money there to do anything with at the time of which the reporting deadline ended, and certainly the reliance of getting up on television and blasting those ads out was on the special interest money that came his way. So I don't know where Judge Scrennock has been. I know he hasn't been at places I've been, even when he's been asked to go there, because he only talks to the people who he wants to talk to. I have made efforts to be everywhere and to talk to all different audiences, because that's what we are. We represent everyone.
Well, let's talk about this further. I think if you talk to a lot of people in this state, they say this race is nonpartisan in name only. And I'm going to ask each of you to talk to the people of Wisconsin tonight about this very issue. Judge Scrennock, you talk about the rule of law. Let's talk about some of the things that you've done as part of this campaign. You, of course, were endorsed by Governor Walker, appointed by Governor Walker, endorsed by Governor Walker.
I don't believe I've been endorsed by Governor Walker. But
I believe he's urged people to get out and vote for you. I believe that he did that on his Twitter account. You have received $142,000 from the Wisconsin Republican Party to help you with your primary campaign, nearly $600,000 in ads from Wisconsin Manufacturers and Commerce. You were just at one of their meetings this past week thanking people there for their contributions. On your Twitter account, you have your handle that says for their support
after winning the primary.
Yeah, and it says "Why Right?" W-I Right on your Twitter handle. Given some of those things, why would a reasonable person not conclude, as your opponent is charged, that Michael Scrennock is going to be a rubber stamp for the Republican administration and for conservative causes?
Well, first of all, because, again, there is absolutely no evidence of anything that I've done on the bench that I've done anything other than follow the law. And so what people need to understand, and WMC is a great example, it should be no surprise that when our business communities and the leaders in the business community look back at what the court was the last time we had a liberal activist court majority, which was in the mid-2000s, we saw in rapid fire succession a number of activist decisions, and decisions that, and when I say activists, they were decisions that were based on the political aims of the individual justices and not based on the law. And people across the state woke up and they said, whoa, what is our Supreme Court doing? That's not what the court is about. That's what our legislature is for. That's what our governor is for. We have two political branches that set policy for this state. And when they set policy, they become laws, and those laws come to the court, and the court's only job is to interpret and apply the laws, not to rewrite them, not to veto policy choices made by the governor, not to include new stuff that never existed before in our laws. And that's what this campaign is about. Judge Dallet is actively campaigning as a liberal activist judge, and I am not. And I am not at all surprised that the business community says, we don't want to go back to the mid-2000s. We want to make sure that we have justices who will simply follow the law. And that's what this is about. Now, I can also tell you this. When I go, because I don't just sit around and meet with people that I know agree with me, when I talk to individual voters one-on-one and I describe my judicial philosophy, you know what reaction I get? Every single time, their heads nod. Deep down, everybody that saw Schoolhouse Rock back in the 70s knows that we have a court who simply applies the law. That's what people want deep down. They don't want a court rewriting laws. And I do not end those conversations with individual voters by then saying, hey, now wait, are you a Republican or a Democrat? Because it is a nonpartisan issue whether you have a court that simply follows the law or whether you have a court that's an activist court.
One follow-up on that. In one of the forums earlier this year, you were criticizing the court, as you did just then back in the mid-2000s. You said they were results-oriented decisions. I don't want to see the Wisconsin Supreme Court go back to that time when we have the majority of justices who feel empowered to do the right thing. Do you think there are people in Wisconsin who want judges to do both, the rule of law and do the right thing?
Well, the right thing should have been in air quotes. And the role of the judge, and I do, and you know what? I actually do it every day. The role of a judge is to interpret the law, to do research, figure out what the law says. As Justice Wilcox told me, go where the law takes you. And you apply that law to the facts of the case, and that is the result. And if as a judge, you get to the end of that task and you say, wow, that's not the result I wanted, too bad. And so what I meant was, if you get to the end of that research and you say, wow, that's not the result I wanted, I'm going to do the right thing, in air quotes, by reaching a different result. Do I think voters across the state want that? No, I do not.
Judge Dallet, I want to come back to you because he says you're a liberal judicial activist, and you've tried to say that, no, I'm going to be impartial, but let's talk about some of the places you've been. You said you've been to a lot of different places, but this week you're touting your endorsement from Tammy Baldwin, the Democratic senator from Madison. You've appeared at the state party convention in Madison. I saw a picture on your Twitter account of you at the rally for Randy Bryce and Bernie Sanders. It's possible that Eric Holder will be in Wisconsin this month to campaign, I assume not for Judge Skrenak. I mean, given some of those visuals to people and given some of those facts, why would people not conclude the same thing except just saying she's going to be a rubber stamp for Democratic policies and for progressive policies? Why would they not come to that conclusion?
Well, I'll say two things about that. First of all, the places I've been also have included showing up at other locations like the Federalist Society debate. There were two debates that, at least two, maybe three, that Tim Burns and I had because Judge Skrenak decided he was too far to go or whatever other excuse there was. What really meant is he only wants to talk to the people who he thinks will like his message. And so I have been many places. I've been to Chambers of Commerce events in multiple cities. I've been to Rotary. I've been to the Federalist Society meeting. I have been all over.
Did you go to the State Republican Party convention?
Actually, it was before I announced my candidacy. I believe it was before June 1st. So I've been
Any Republican
open
events?
to talking to. I've been to places where there have been plenty of conservative people, and I have people who are conservative backing my campaign. I will point to the fact that I have over 200 judges backing my campaign. They are supporting me because they understand that I'm the only one in this race who is going to be fair, who is going to be independent, who is not going to be a rubber stamp. Some of those judges were endorsed by or appointed by our governor currently. Some of them have run for office or been appointed or been from rural or urban areas. And to me, that is the best testament from the people that know our courts the best of who's going to do the best job at this job, be the best justice at this job. When we talk about the phrase activist judge, my opponent likes to put the word liberal in front of it. Activist can be anyone. And I will tell you, and I think that I don't have to tell the people here in this room because they know it. They know that the work that the court has been doing has been extremely activist. I can just point to a very recent case, the open records case involving MTI, a teachers union. The teachers union wanted to get records. Open records is supposed to be where you start, and you're not supposed to deny open records unless there's something in the record, something there for you to do it as a judge. The justices on our Supreme Court, they read into the record. There wasn't anything there. They read something in there so that they could deny MTI open records. We absolutely have an activist court right now. My opponent wants to be part of that activist court. And why WMC swooped in to save the day is because they want the activism to go in their direction.
I'll give him a chance to respond. Quick question. Do you welcome Tim Burns' support?
Yes, I welcome everyone's support. Absolutely.
Yes.
My opponent has trumpeted her judicial endorsements from last summer on. And I've talked with some of those judges, not recently. But I think it's important that the voters understand that, as Mr. Burns pointed out at our last forum, my opponent switched her message, and I would say right around mid-December. And at that forum, I was actually surprised she actually debated with him and said, no, I didn't. No, she actually, I mean, it was very clear that she did. So I'll tell you a couple things that I heard. I talked with a judge in late summer, early fall, and he said, you know, I'm supporting Judge Dallin. And I said, really, why? He said, well, I've thought it through, and I think she's the least likely to politicize the race. And I almost can't say that with a straight face now after she came out with her first TV ad that leads with President Trump, an attack on our president, as if what the president does has something to do with our Wisconsin Supreme Court or this race.
Do you regret that ad?
That ad was exactly what I've been talking about since the beginning. It was about our values being under attack, and there's nothing politicized about it. We are all dealing with the way that our country has gone and our state has gone, and it doesn't matter whether you're a Democrat or Republican. You are feeling the effects of all of this attack. Look at what just happened in our schools, for God's sake. Look at what we are facing right now. This is where we are right now, and we have to address that, and that's an important issue.
Let me go back, yes.
Let me tell you what has changed since she first announced her candidacy in June. And she got a lot of the judicial endorsements before mid-December. And I'll tell you what she wasn't saying prior to mid-December. She wasn't saying, at least not publicly that I ever saw, that she was going to be an advocate for policy change from the bench. That is a huge thing. That is, you know, whether individual voters recognize what that means or not, judges understand what that means. And on January 17th, in a rule of law garbage speech, she ended by saying, experience matters to get the policies we want. Now, when I heard that, my antenna went way up. As a judge, you know what that means. That means an activist court. That means an activist judge. And it came right after she had read off her litany of liberal political issues that she cares about. On February 8th, she said she's going to advocate for the policies that need to be changed in order to advance those political issues. Now, I'll tell you this. Those individual judges that continue to endorse her, they need to answer for their own constituents, if they're concerned, why they're still endorsing her. Because I promise you, most of those judicial endorsements were obtained before she made it clear that she intends to be an activist judge.
When I'm talking about policies, my opponent seems to forget that part of what our Supreme Court does is make policy that directly relates to our courts. When I talk about policies, it is the experience, the deep experience that I have working in our courts and an understanding of the kind of policy setting that that court does absolutely do and needs to do. That is what that's referring to. This is the danger of taking people's words out of context for political gain, which my opponent has done and continues to do. We have a court that can set things like, for example, there is a rule hearing right now taking place on what people are paid to take appointments of cases that the public defender can't take. That is a policy that affects our court. We have a real problem in our state, and it affects our rural counties more than our urban counties, where we do not have people that can be represented because no one will take those cases. They are paid $40 an hour, and it is not right. That's a policy I will absolutely advocate to change. We have an opioid crisis. It is ravaging our state. If you get to the West, the methamphetamine crisis is ravaging our state. We need a court that is willing to conduct hearings to get policies that affect our courts that are going to help the people in our state. That is a function of our court. That is exactly what I was talking about.
No, it's not. You're talking about policies to protect your values, which are workers' rights, women's rights, clean air, clean water, full funding for schools. Those are the things you're talking about in those speeches. And then you say you're going to advocate for policy change. You're right. The Supreme Court does have a policy-making function, but that's not what you were talking about in those campaign
I'm glad
speeches.
that my opponent knows what I was talking about or thinks he does. I don't even...
Let me talk about something that I think maybe crystallizes the difference in your judicial philosophies, and that's the Act 10 ruling by the state Supreme Court. This is a case you're very familiar with. As a private attorney, you defended it. You have criticized it. I want to hear from each of you. I think our audience would be interested in why you think, Judge Scrennock, Act 10 was the ruling was correct and why it was good law, and why you think it was bad law. Go ahead.
Well, I don't know where this conversation will go, but I'll say this. I'm not going to get into re-arguing Act 10 here because the issues that the court dealt with in Act 10 very well could come back before the court in a different setting. And so I think it's dangerous territory for us to get into re-arguing the case.
Because of the federal lawsuit? Well,
it could be anything. You've got a right-to-work law out there that I wouldn't be surprised if it was challenged at some point. And yeah, the federal lawsuit demonstrates that Act 10 could come back in any number of forum or fashions. But what I'll say to the voters is I believe Act 10 was correctly decided. I believe it was correctly decided at the Seventh Circuit Court of Appeals, where you had one dissenter who dissented on one very, very minor piece that the judge would have analyzed differently, but said, used the phrase, the principal provisions. The principal provisions of Act 10 were completely lawful. So with respect to the principal provisions, you had 3 appellate judges. That case was never appealed to the U.S. Supreme Court. And the state Supreme Court, anyone who's interested in the case and wants to actually read about it should read Justice Crooks's concurrence. Justice Crooks, at that time we had a 4-3 court. People believed Justice Crooks was part of the 3. He was not viewed as a conservative justice. He certainly was not viewed as some shill for the Republican Party. And he agreed with the majority that Act 10 was absolutely lawful. He actually said it's not even a close call. And he said when we view the decision, we review the law as a matter of law, which is the court's job, he said we will uphold it. Now, he wrote 8 pages. And the reason he wrote 8 pages is because he thought it was a horrible policy choice. And he lectured the governor, and he lectured the legislature, and he cited the Pope, and he cited Bob La Follette, and he cited Ronald Reagan. But as a justice,
a diverse group of folks.
It was a very diverse group of folks. But at the end of the day, as a justice on our Supreme Court, he understood his role. And he said, when we view this as a matter of law, which we will uphold it. It's not even a close call.
I should have prefaced this by saying, of course, Act 10 was the legislation that eliminated most collective bargaining rights for most public employees. But you have said bad decision, bad law. Why?
Well, you can also preface it by saying that my opponent touts his work on that and did in order to get his appointment to be a judge currently. So it's to ask him about whether it's good law or not, of course, that's what he thinks. But the problem with Act 10...
whether it was correctly decided.
Well, the problem with Act 10 is it's a good example of our activist court. It is. Because when we're talking about applying the law and rule of law, the job of the Supreme Court is to look at laws written by the legislature and apply our Constitution. If all the Supreme Court did is what my opponent seems to be saying here today, just apply the law. Well, you don't need a Supreme Court to do that. The legislature writes the law. Let's just apply the law. No, the job of the Supreme Court is to be a check on the other branches when they go too far. When they violate our rights as set forth in the Constitution, that's where the court steps in. And that is not always clear, as somehow Mr. Scranach appears that it is or thinks that it is. In the case of Act 10, the issue was involving a right and a violation of that right. That was the claim. The majority analyzed the case under the right to collectively bargain. There's no such right. If you read Justice Ann Walsh Bradley's dissent, she acknowledges if you're going to analyze it under a right that we don't have, of course it's fine. We do have a right to association. And somehow, in their effort to get to the end result, the majority seem to have missed that and analyzed that entire case improperly. It's a clear example of a court being activist, getting to an end result, and not really looking at the rights that are upheld in our Constitution. And that's what we expect from Supreme Court justices.
I'll give you a couple minutes to respond to that.
Yeah, thanks. I absolutely believe in it. In fact, I've said this on the campaign trail many, many times. The court has a solemn duty to rein in the other two branches of government when they have exceeded the constitutional boundary. Absolutely. It's their most important function, and it must do it. And quite frankly, I've talked with legislators individually who have told me they want the court to do that if we go too far, you should tell us. But if we don't go too far, leave us alone. And they don't use those words, but that's the court's job. Now, this is why I don't talk about cases that I haven't had a chance to read fully, read all of the briefs and read the decisions in depth and really understand whether I would have reached a different decision or not. And I've heard my opponent talk about Act 10 in the way she did because she's read Justice Ann Walsh Bradley's dissent and believes she got it right. The reason that the majority opinion is written the way it is, and apparently Judge Dallet doesn't know that she must not have read the actual briefs, is that the way that the plaintiffs framed the issue on the right to associate, is they claimed that it violated their right to associate for the purpose of collective bargaining. That was the claim. It wasn't just we don't have a right to associate. The law didn't prohibit individual employees from creating a union, creating any organization. It didn't prohibit them from meeting. It didn't prohibit them from petitioning their government. What it did was it took away their right to collective bargaining, which is a statutory right. And the constitutional issue was creatively framed by Attorney Lester Pines as a violation of the right to associate for the purpose of collective bargaining, which is why the majority decision was written the way it was.
I've got a couple of minutes left here, and I want to raise something that is a suggestion from a few years ago. The State Bar's Board of Governors, back I think it was 2013, 2014, voted 37-4 to say, because of some of the pressures that candidates like yourselves face in these races, some of the outside pressures you face, maybe we should go to one 16-year term for a Supreme Court justice. You never run for re-election. Once you're elected, you're on for 16 years. How do you feel about something like that? Would it make any difference in the tone, the way our campaigns look and sound in today's world? Judge Dallet?
Well, we need to do something, Mike. I mean, it's very clear that these races have become about the special interests, and they've been successful, these special interest groups, for the last decade or so in buying justices. They're trying to do it now with my opponent. We've got to get away from the special interests taking the place of the people of our state. The people of our state are the ones that need to be involved in electing justices. I've talked about on the campaign trail potentially other states have merit-based, some kind of merit appointment system and retention elections. I mean, there's all kinds of things we should absolutely have discussions about. We first need to acknowledge the problem. The problem being this money and the way it's poured in and the way it's driven out the ability to have independent, fair courts that people have confidence in. That's what we need to do.
We're going to have closing statements in a moment, but I'll give Judge Schrenak about a minute and a half to address this idea of one 16-year term for a justice on the Supreme Court.
Well, it would require a constitutional amendment,
right.
So I'm not sure what my thoughts on it would matter. What I will say is that I trust the voters.
Well, just as someone who would serve on the court, who runs for the court, I'd be interested in your thoughts.
Well, the system that we have now, we have 10-year terms. It's the longest term that we have for elected office in the state. And the reason was, as I understand it, that was chosen in order to allow justices on our court to not feel beholden to anybody. That a 10-year term was long enough that once you got elected, you would do your job and not be worried about your next election 10 years from now. Whether that number is 10 or 16, I guess people could talk about. But 10 years is a long time. And I've heard Senate candidates who'd said, look, elect me and I'll serve one term if that's what it takes to get the job done. 10 years is a long time. Now, what I will say is that what the voters need to look at is, do they trust the candidates? If you can't trust a judge or a justice to actually do their job impartially, they don't belong on the bench for even 2 months. And so the voters need to trust that we have the integrity and the moral character to do the job, and I am committed to doing that job without injecting my personal beliefs into any of my decisions.
And you're still going to have a minute for your closing statement here, too, in a second. It is time now for closing statements. We flipped a coin to determine the order, and we're going to begin with Judge Dallett.
Thank you. This is a critical time in our nation's history. Our institutions, those that have held up our great democracy for more than 200 years, are under tremendous assault. Special interests, many of whom our founding fathers warned us against, have huge power. I'm running to change that. What we've heard tonight is a political figure spouting the same tired talking points to appeal to the far right wing and further politicize the judiciary as Scott Walker's rubber stamp. My opponent is bought and paid for by the big-moneyed special interests that have had far too much influence over our court in recent years. I have served the people of the state of Wisconsin for over 20 years, helping victims, prosecuting criminals, and upholding the law. During my 10 years as a judge, I have handled more than 10,000 cases and put my values in Wisconsin to work. It's time to bring back Wisconsin values of independence and fairness, and that's just what I'll do as your next Supreme Court Justice, and I'd appreciate your vote.
Judge Schrenak.
I am running because I care deeply about the state of Wisconsin and the rule of law. I was born and raised here. I went to school here. I raised my family here, and I have dedicated my professional career to serving the people of this state. I'm a judge now, and I served as an attorney, and I know firsthand the importance of a court upholding the rule of law, protecting public safety, and respecting our Constitution and the separation of powers. I also know the dangers of a court legislating from the bench. Judges are not legislators, and neither are we executives. Our job is to interpret and apply the law, not based on our personal or political beliefs, but based on the statutes and the Constitution. Simply put, the role of a court is to be an arbiter of the law, not a policy analyst or a political activist. I've been endorsed in this race by a bipartisan majority of Wisconsin sheriffs because they understand that our highest court needs an impartial justice, not a partisan activist.
Judge Schrenak and Judge Dallett, thank you to both of you tonight for being with us. We appreciate it. And we also want to thank everyone here in Eckstein Hall and those of you at home for watching. This debate has been a production of WISN 12 News and Marquette University Law School. Election Day is Tuesday, April 3rd. We encourage you to get out and vote. I'm Mike Goucher. Thanks for being with us tonight. Have a good evening.
This has been a special presentation of WISN TV and Marquette University Law School on the Upfront network of ABC stations in Wisconsin. Thank you for joining us.